Okay, we are back. We are back. We are now on Chapter 7. Chapter 7, Federal and State Laws Pertaining to Real Estate. So for the most part, as you learned in high school, when you're dealing with federal and state laws, usually your federal law is going to supersede your state law. So the purpose of this chapter is to let you know some of the state laws versus the federal laws and how they kind of work together, how they came about to be. For example, on page 145, you have the Civil Rights Act of 1866 that prohibited any type of discrimination based on the basis of race. Now that one stopped based on the basis of race at that point in time. 1866 based on the basis of race, no discrimination. They have added on to it over on page 147. Now you've got added on to it, you have the Civil Rights Act of 1964, Title II and Title III. And then on top of that one, the one that has the additionals that were added on, the additional classes, Civil Rights Act of 1968. Now you have the Fair Housing Act, and it covers no discrimination on the basis of race, color, religion, sex, national origin when selling or renting residential property. Okay, so it started with one class and now we've added on, got some more classes. We don't want to do that anyhow. We want as many people as we can that wants to purchase real estate. That's what we are here for, the state of Florida. On page 147, it goes on and it actually lists all the 7 classes in the 7 protective classes. Make sure you know those 7 classes are there for you. Okay, fair housing poster down to the bottom, you've seen that, and hopefully in almost all of the real estate brokerage that you go to, you have the lovely fair housing poster, and that's there. You know, we do abide by those rules. One of the things the book teaches us, by a broker having there, that's one way they're showing that they're not being discriminatory. On page 149, it talks about housing for the older person. As you know, in our area, we actually have some areas where, you know, you have to be a certain age in order to move in. So there's a lot of protection, which is a good thing for the people of certain age. Over on page 150, they have some prohibited activities: steering, blockbustering, redlining. No, no, and don't do, okay? Steering is when you're taking someone that's in one of those 7 classes that we just went over. It tells you to or away from a particular neighborhood because they are in one of the 7 classes. So let's just say you got someone, I'll use me, African American, okay? Just in case you didn't know that. And let's just say I wanted to move into a certain neighborhood and you didn't want me to move into that neighborhood because I am an African American girl who wears a red blouse, okay? And you try to steer me into a neighborhood where all of the African American females wear red blouse. I don't want to be in the neighborhood with a red blouse. I want to be in the neighborhood where they wear the pink blouse, okay? So anyhow, but you get the picture. Steering is trying to steer them away from someone that's in one of those 7 classes. You're trying to steer them away from a particular area or neighborhood because they are in one of those 7 classes. That's illegal, can't do. Blockbustering, now you're going to use a rumor to try and get someone that's in one of the protected classes out of the neighborhood. You know, so you come along and you say, hey Bernice, listen, I hear that the females from Timbuktu are moving in and they're not going to be wearing orange blouses. They're going to be wearing only purple. So you're still, now that I've moved into that neighborhood, you're trying to get me out of that neighborhood because I'm in one of the 7 classes. Make sure you understand. They're trying to get someone, they're discriminating, trying to get someone to move out of the neighborhood because they are in one of those 7 classes, and they do it by using a rumor. Remember when they told me that they heard? They're using a rumor. Redlining, denying loans or insurance coverage by a lender or an insurer that presents different terms or conditions for home in certain neighborhoods commonly called redlining. It is illegal. You can't do that. So here again, 3 activities that are prohibited: steering, block pursuing, redlining. Don't do it. They have some other bullets down there: refusal to rent, to sell, or negotiate with. The other ones, guys, make sure you read over them. But they're pretty, they're pretty open. When you read it, you can see like, well, you can't do that anyhow. Okay? No, you can't go refusing to rent to someone or to negotiate with someone because they're in one of the protected classes. You can't do that. Quote different terms, advertise differently, denying membership, make false statements. No, 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 and no. You cannot do those things, okay? That's what it's talking about. Over on page 151, now you've got complaints filed with HUD under the Fair Housing Act. Person who has 1 year from the day the discriminatory act occurred to file a complaint with HUD. So from the time that the event happens, if you find yourself in that situation, or it's someone else that you may know of, you got 1 year from the time that it happened to actually file the complaint with who? You file it with HUD. Action taken by the Department of Justice may initiate a suit in federal court if there is a breach in the consolation agreement of such. Okay? Down below the Fair Housing Act, they tell you what the objective is of that act. It is to provide for fair housing throughout the state. As many people as we possibly can want to provide fair housing for them. That's basically what it's talking about there, okay? If you flip on over that fair housing case that's on page 152, read over it, guys. It's pretty enlightening, and it's something that will kind of help you as well throughout the course. Flip on over to page 154. They're now talking about Americans with Disability Act. Here again, as you know, you can't discriminate there either. You just can't discriminate. Just don't do it. No, you can't discriminate against the color of the birds and things like that. Don't do it. It's actually a much more pleasant life when you just kind of learn from people of their differences versus trying to discriminate against them. But anyhow, back to the book. As we are saying, Americans with Disability Act of 1990. American with Disability Act is a federal statute that protects employment and accessibility rights of individuals with mental and physical disabilities. So access to public transportation, public accommodation, commercial facilities, all of those things that act covers, and those are things that must be in place for people with those type of disabilities. Okay, talks about down below Florida Americans with Disabilities Accessibility Implementation Act. The state statute adopts the federal standards in Florida for accessibility for disabled people. Sorry about that. So that's what you're looking at there. Down below we have Interstate Land Sale Full Disclosure Act. This concerns advertising and sale or lease of real estate in one state to buyers in another state is subject to federal regulations. Okay, and it goes on and talking about the Interstate Land Sale Full Disclosure Act, ILSA. It requires disclosure of the full and accurate information regarding the property to prospective buyers before they decide to buy. It's administered by the Consumer Financial Protection Department, and the developers must register subdivisions of 100 or more lots with that bureau before they can offer unimproved lots in interstate commercial by telephone or through the mail. On top of that, also, the report, I'm sorry, I had to look at something else real quick. If developers have developers of 25 or more lots, they must also provide a proprietary report prior to the signing of the contract. That's on your page 155. So because of the Interstate Land Sales Full Disclosure Act, these laws are there also to help buyers when they are looking into purchasing land to build on. And those are some of the things that it covered there. Florida Residential Landlord and Tenant Act on page 155. Make sure you know concerning the deposit and the advance rent. Yes, those security deposits are to be held in an interest. You can put it in an interest-bearing account. You can put it in a non-interest-bearing account. You can use a post-surety bond. That's what the three of those bullets are talking about under deposits and advance rent. Those are the three areas you can hold those deposits in. Now, you do need to let the tenant know where you're holding that escrow money at. That is one of the things that's included in this reading here, okay? Over on page 156, it talks about how some brokers actually will have a property management account for the property management rentals, and it specifically says on line 13 on page 156. This is good information also for brokers if you are going into the property management area. It tells you the deposit and advance rents are trust funds, and as such must be deposited into the broker's escrow account by the end of the third business day. You've heard that before, guys. By the end of the third business day after receipts of the trust fund. So, but here again, the brokers, you can get a separate escrow account. You can get a property management account for your client when you're dealing with the property management, and you can hold the funds in there as well. Down below and on the next page, now they're talking about, especially on page 157, they're talking about the landlord's obligation to maintain premises. Those four bullets are the things that landlords are responsible for. And I often get this chuckle on number 9 when it tells you provide working equipment for heat plus running hot water. I'm going, we are in the state of Florida. If we just put pails of hot water outside in the sun, well, pails of water, just give it that day. By the end of the day, it'll be hot anyhow. So there you go. Okay, that's this little thing with Bernie's. But make sure those four bullets you're clear on as far as what the landlord's responsibility. Then, of course, on page 158, it talks about the tenant's obligations, the things that they are required to do. Access to the premises, the landlord, he does have to give notice when he is going there. It tells, those four bullets there tells some of the reasons for them actually going onto the property. So landlords can't just like, oh, I want to go and check my property out today without any notice and just to check it out just because they want to check it out and just want to take a picture by their property. No, 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 okay? There's certain rules that apply. Vacating premises, it specifically tells you, line 24, landlord has 15 days to return security deposit and any accrued interest if applicable. Line 27, landlord has 30 days to notify the tenants of intentions to impose a claim on the deposit. How do you study that? Go over to page 159 in the gray box. Index cards. 30 days, landlord of 5 or more units must notify the tenant in writing which method they're going to hold the tenant's deposit. I told you that. So whether it be interest or non-interest bearing, you gotta let them know, or post-dated check. Make sure you know about the 15 days that he has if he intends on making a claim on the security deposit. 30 days if he's going to make, if the deposit has 30 days to notify the tenant of the claim, and 15 days after receiving written notification of the landlord claims on it, okay? Those are some of the main things. The last thing concerning the eviction part of it, if you get to that point, you gotta make sure, read over those, but make sure the sheriff is there after that process is done, okay? Before you can go throwing things out is what you're looking at. Guys, if you have any questions on that chapter, let us know. Let's take a quick break and we'll go back to the next.